weekend that was saying that this weekend was the start, basically this is the start of the pandemic in Oregon. And, so we've been doing this a year now. And I really, really appreciate how easily and effortlessly it has seemed to move to this platform with all of you. I know we were really scrambling and the technology was a challenge in the beginning, and I feel like we've really made great progress over the course of the last year. Much more than if you had told me this time last year we would be doing this remotely for a year and year plus, because I think lawyer and adjunct professor 1B doesn't start until May. Um, but I just wanted to really thank all of you, because the success of this project is really owes a huge debt of gratitude to all of your willingness to have these Zoom meetings, and still go over and have a thoughtful discussion about this. Meanwhile, you've got kid and family and pandemic and forest fire and all kinds of chaos going on in your lives. So I just want to take a moment and say thank you, because it's been a hell of a year for all of us. But I really appreciate your willingness to stick with this project and to, you know, and to keep moving it forward, because I think it'll be important for the state of Oregon and for all of our clients and our colleagues going forward. And the fact that you've managed to do this in the middle of a pandemic is just that much more amazing. So what I really want is I want them to put a thing at the beginning of chapter 63A that says this is even more amazing than normal legislation because of what we had to go through while we were doing this. So thank you very much. So for purposes of this session, what we thought we would do is start with Cody's language that was emailed out yesterday. And Cody, if you wouldn't mind walking us through that, and then we'll switch back to James. And I think we're on section 906 is what my notes say. And so we'll start with that. And it looks like Cody, Sandy has made you the host, so you have all the power now.
Yeah.
I know. Don't let it go to your head.
Thanks. I did that in case you wanted to share your screen.
No, I'm okay. I'll just walk through it. Thank you. I mean, now that I do have the party, I just want to let everyone know I will be elected a third time. Probably next year even. We'll just get it done with faster.
Oh, Sandy's reclaimed the power.
Oh, darn it. That's illegitimate action by Sandy.
It was stolen from you, I understand.
So I'll just briefly say what are the differences between the document that Sandy sent out yesterday and what he had sent out a month ago, which we discussed. Yeah. And all but one change essentially is just fixing typos or little things that were missed that were called out by Jeff and others on our last call. One thing is I added at the very top that I added the just an informational notice that subsection A1 adds relevant provision from ORS 60.9521, which is the definition of the closely held company. There was a reference in section A there to shares in that definition of what is a closely held company. I think Willie was the one who had noticed that was there, and I changed that to interests. In section A2, there's a reference to the notice shall state that in the second sentence, the notice shall state the name of the member who filed the proceeding under section 701A4 and the whole transferable interest. I changed that to entire interest, including the transferable interest, which is consistent with what we had been doing elsewhere. In the following sentence, there was a reference to the election to purchase shares, which I changed to the entire interest instead of shares. Jeff had called out, moving down to the next page, that there was subsections E and F, which should have been 5 and 6. So I changed those references. At the start of B1, it says the court shall, and I changed that to if the court orders a purchase under section 807A6, the court shall, because otherwise it just seemed a little acontextual, like when will the court do all these things? So that just clarifies that. So none of that I don't think is substantive. I think that's all just fixing errors and things, omissions in the prior version. The substantive change has to do with what we had all discussed regarding section 105C and how we were going to add in something saying that you can get rid of Section 807 entirely per your operating agreement. But if you're going to be subject to it, then you can't modify it. And so what the original proposed language was that the operating agreement may not vary the provisions of Section 807, but the operating agreement may provide that the company and the members will not be subject to Section 807. And James and some other people wanted some greater clarity on that. And so I came up with some language, ran it by James as well as by Aurelia and Kyle and Mosen. And the replacement language is essentially the same as what we had before, except for we add some additional language saying the members will not be subject to Section 807, in which case the operating agreement may also provide for alternative means by which the company and the members may purchase the entire interest or transferable interest of a member who files a proceeding under Section 701A4, which we think makes it clear that you can totally override Section 807 with whatever you want contractually. But if you're not doing it by the contract, then you can't sort of tinker with 807. You either sort of replace it with something else or you don't. And if you replace it, you can kind of do what you want. And if you don't replace it, then you'll be subject to 807 as it's written.
Yeah, that's reasonable to me. I mean, and I think that the changes that you made to this document reflect, the discussions that we had last week and a lot of the concerns that people raised about, ambiguities and pulling it over from the corporate side of things. But, I think this is one of those areas where I think it's an improvement because courts are already generally doing this. But, I think it's one of those things that we are going to have to flag for our members who, aren't going to know, this is not going to be in their, okay, this is something that I need to address in the operating agreement. So to the extent that we're talking in education and CLE about advising clients on how to draft operating agreements or advising our peers on how to draft operating agreements, I think we'll have to make sure we bring this up just so they know on an educational perspective. But thank you very much. Thanks to all of you, because I know this was a lot of work to pull together, and especially to you, Cody.
Valerie, I did have a question, and I do apologize if this was covered last week. I had to step out for a client meeting and then came back in, so I may have missed some of the discussion. And Cody, appreciate your work on this. I think this is a good addition to the act. I mean, I think of our carpet layers that may not have any operating agreement at all. I think has sort of an escape hatch that allows them to potentially move forward. My question is the limitation, or really what I would call the on-ramp into this section referring to 701A4. Looking at Chapter 60, the Corporate Act, really the on-ramp is in a proceeding by a shareholder in a corporation. Which is not necessarily 701A4 is an action about dissolution of the LLC. So it seems narrower than the on-ramp, if you will, under Chapter 60 if you're a shareholder in a corporation. And I just wonder if and I don't know if you talked about this last week, if that was intentional or we might consider broadening that on-ramp in the act. Just a thought.
Sure. So 69521 talks about that if certain circumstances exist, then you can get certain remedies that are the remedies being described in subsection 2 of 952. And the ultimate remedy described in 952 is dissolution. And it also describes lesser remedies.
Yeah, it's one of the remedies.
Right. And in the LLC Act, we don't, we have the dissolution provision, but we don't really have this list of lesser remedies. We have a clause that says you can order lesser remedies than dissolution. And 60952 is, so I'll back up there just as sort of some history of 60.952 is for that we have a separate provision in our corporate code that just talks in general for non-closely held companies in particular, that you can seek dissolution, and that's all it says. And then our corporate code is similar, or was similar at the time, to other corporate codes. Courts around the country had divided over the question of, when you have a statutory authorization for dissolution, can a lesser remedy be ordered instead of dissolution? And our Supreme Court decades ago came out and said, yes, of course, you can do something lesser. But other courts in other jurisdictions had said, no, it's either dissolution or no relief. Yeah. And in 952, which this was the sort of the NATO bill over that,
right.
that
series, I remember that.
What they did in section 2 here of 952 is essentially they codified that rule of Oregon law, making clear that you can stop short of dissolution. And if you look at 952 2M, it says the dissolution of the corporation, if the court determines that no remedy specified above is sufficient to resolve the matter in dispute. And so 952 is generally referred to as the dissolution statute, even though it does say you can do these lesser remedies. And when you compare that to ROLCA, we have the 701 is our dissolution statute. Here are the things that can cause a dissolution. And that's under 701A. And then 701B says, in a proceeding brought under subsection A4C, the court may order a remedy other than dissolution. And A4C is when there's oppression or illegal or fraudulent activity. So
Cody, can I just add to the history of this, that courts most often, actually, if you do sort of a survey of like what courts have ordered in terms of remedies, a share purchase is one of the most common.
Right.
Yeah, and a share purchase is specifically mentioned in 60952 sub 2K. One of the remedies the court can order if there's this deadlock or illegal, oppressive, fraudulent conduct is the purchase by the corporation or one or more shareholders of all of the shares of one or more other shareholders for their fair value and on the terms determined under subsection 5. And subsection 5 is one of the provisions we have pulled over into ROLCA, this ROLCA section 807 as we're calling it.
And I guess my question was really the on-ramp to get into this section rather than the ensuing remedies. So if you have an LLC member that feels that they've been wrong and is basically just suing the company, probably bringing in the managers as defendants as well, do you think this 807 could be utilized? And in my example, they're not suing for dissolution under 701A4.
So the answer is it's not an exact match, because the causes of dissolution, I'll just use the phrase dissolution because under both Oregon statute and ROLCA, you can seek a lesser remedy, at least in certain circumstances. ROLCA says you can seek or you can get at least it specifically authorizes a lesser remedy if it's an oppression or illegal or fraudulency claim. And when you look at 60.952 sub 1, what are the sort of substantive bases on which you can seek dissolution? Well, 1B is that the people in charge are acting in a manner that is illegal, oppressive, or fraudulent. So that is a match with what 701A4C talks about. And that's similar to also what 701A4A talks about with the company's activities being unlawful. And then the other basis listed in ROLCA is it is not reasonably practical to carry on the company's activities and affairs in conformity with the certificate of organization and the operating agreement. And I think that is kind of similar to the deadlock that's referenced in 60952 1A and C. If you've got the people in charge are deadlocked, I mean, I personally think that it's not going to be reasonably practicable to carry on your business anymore, although it's not specifically listed as that. Also, 6952 mentions waste or misapplication of corporate assets, whereas ROLCA doesn't specifically talk about that. So there's this waste concept, and theoretically, potentially, one could argue deadlock is a separate thing that ROLCA doesn't have as a triggering event for a dissolution, and therefore also not a triggering event for this mandatory statutory purchase option. But we thought, rather than monkey with section 701, which is kind of what I think we'd have to do in order to mirror more precisely what the current corporate statutes give you as grounds for dissolution compared to what ROLCA gives you as a ground for dissolution. We thought it was better just to leave the ROLCA grounds because, as I said before, I think the real substantive difference arguably is that ROLCA doesn't talk about waste. I think that's really the only sort of one there that matters, because they both are talking about, and when you think what are the owners suing each other for, it's usually oppression is the biggest thing. I think that's when you have your minority owners suing the majority ones for oppressing them.
Right.
So I think the on-ramps, they're not identical, but they are, I think the critical ones are, and I think in general, they're very close. And if we wanted to make them truly identical, I think that would require us to modify ROLCA section 701, which we could choose to do, but I personally, I don't think it's necessary.
Okay. Understood.
But others, I mean, anyone can have, if others feel differently,
No, I think Cody, you summarized it really well, and that's our thinking on it, which is that the on-ramps make sense, especially if we were deferring to the ROLCA model, right? And using that as our sort of basis. And there are some differences, but we didn't think that they were significant enough to really change. So.
Okay.
So quick question on actually going back to 701, and sorry I wasn't here last week, you guys probably covered this, but where I see a lot of potential issues with managers of an LLC having conduct that could be detrimental to members is even with respect to tax elections or possibly conversion of an LLC to a corporation. They could have negative tax consequences to certain individuals that may not be in power. Now, with that, looking at those situations, in your guys' opinion, do you think those could rise to the 701 C4 standard of being essentially oppressive and directly harmful? And I can give you like a specific example. If an LLC was going to convert to a corporation and the corporation had, or excuse me, the LLC has liabilities in excess of its basis, so there will be tax consequences to the members of the LLC that is detrimental to them because they would have taxable income resulting from that conversion. Again, is that something that rises to this that would then trigger this chain of events?
I think that two primary responses, or three. First is the clarification that I haven't litigated a case like this in the context of a conversion to a different type of entity. So I don't have direct experience to speak from. Secondly is, the claim, or what is the relief being sought here? It's going to be generally a dissolution. Maybe I guess the lesser relief being sought potentially would be a block of the conversion or a conversion on modified terms if there's really that oppression going on. So I guess it would be an attempt to block the conversion. I've never heard of such a claim being brought. I think in the ultimate determination of whether it's oppressive, the question is going to be, is this sort of a legitimate business decision that, reasonable minds could differ? Maybe there's an element of the business judgment rule that applies here. Whereas by contrast, then it's going to be okay, it'll get blessed. But I think perhaps if the conversion is part of a squeeze out, something like that it's like, oh yeah, we've been running the company poorly for a while, such that now our liabilities are exceeding the basis, and now we're going to convert, and the people with the power are going to get a more favorable tax treatment, and the person who's getting squeezed is going to get a less favorable tax treatment out of this, and maybe they're going to have a extra wimpy ownership in the new company, or whatever form it takes. Then I think that's an example of something that could be oppressive.
Well, and that is not an uncommon scenario, right? For private equity groups, I've actually seen that quite a few times, where founders will essentially get squeezed out in a conversion. And I don't know that that's.
I think Mosin wants to talk too. He raised his hand politely, unlike the rest of us.
Well, my question deals with a separate issue, although I have Cliff's concern about this language in the statute to begin with, but I don't mean to reopen Article 7. But I can ask my question, which is separate, but we can also finish discussion.
Okay, well, yeah,
I do have the same concern that Cliff just voiced, though.
Okay, so let's finish up this discussion then, Cliff, because I didn't mean to interrupt you, but I wanted to make sure we heard Mosin.
No, I guess I was just wanting to make sure that I'm not the tax expert. I just deal with a lot of the conversions and private equity deals where people are getting squeezed out. And I just want to make sure we're not creating any additional complications for these groups that are trying to take those actions.
Well, I guess so. With regard to what we were talking about with 807, this has no effect on that. 807, this new section coming from the corporate purchase provision doesn't affect what are the grounds of dissolution in itself. It just talks about it gives the majority owners an ability to buy out the minority who's complaining if the minority owner brings dissolutions action. So this doesn't affect what are the grounds for dissolution under 701. So if we're going and sort of not talking about this 807 concept, but instead just sort of reopening the discussion under 701 as what do we want to have be grounds for usually a minority member to be able to sue a majority member, then I think it's important to remember we already have a cause of action for oppression under Oregon law. That's not adding anything new to have it be in the statute. So I don't think this actually expands what the minority member can do. It's just putting it in black and white. What's already there in black and white in the Oregon reports, and now it puts it in the ORS book to the degree that people still have books.
Okay.
I have books.
Yeah, you do, Valerie.
That makes sense, Cody. Thanks.
Okay, yeah. Go ahead, Mosin.
So, Cody, this comes back to 807 now. And you shared this language with me, I think, last week, and I drafted this long email about what I didn't understand. But then I thought, there must be something I'm missing here. So let me just ask it in person. I don't understand this language. I don't know how to explain this language to a student. That the operating agreement may not vary the provisions of 807, but the operating agreement may, right, all that like that part. So here's what that reads to me. You can't vary 807, but you can opt out of 807. And if you opt out of 807, you could do whatever you want in terms of some alternative buyout mechanism that may or may not mirror 807 as much as you like. So that reads to me to say, on the one hand, you can't vary 807, but by contract, you can vary 807.
Yeah, that's right. So this kind of comes from the core language there is coming from what ROLCA itself provides with regard to special litigation committees, which we decided not to have. But ROLCA has essentially the same language. They say, with regard to those special litigation committees, which are described in section 805, it says, you cannot vary the provisions of Section 805, but the operating agreement may provide that the company may not have a special litigation committee. And so I thought, well, you know, if we're going to have the same concept here, let's copy their language. So you may not vary the provisions of Section 807, but you can, you know, opt out of 807. And I think that what do I think? I think in part, if you want to be a transactional attorney who's really being clear that you're taking advantage of this opt out, I think you want to try to put the magic words in. We are opting out of 807. We're not just trying to do an illicit varying of it. I don't know that magic words are actually required, but I think you'd be very safe if you used the magic words.
I don't think you can have, I mean, I'm not blaming you if this just comes out of language from Rolka, but I find it immensely confusing to say you can't vary 807, but then if you opt out of 807 and then include something in your agreement that looks a lot like 807 but varies certain aspects of 807, that a court might look at that second part and say, well, you're varying 807, which you clearly cannot do.
Listen, I think the point is that you can't opt out and leave people hanging, because what that does is it puts them back into this common law thing that we've been, you know, the courts have developed over the last several years, that really was why Aurelia and Cody and the litigators in the group said that they wanted to incorporate this provision. And so if you don't have a provision that deals with the situation, then your opt out, I think, is ineffective, right?
Is that correct?
That's not how I read it.
Okay.
Yeah, because then that may should be a shall. In which case the operating agreement shall also provide rather than may. Because if that's the case, Valerie, then I kind of understand what this is getting at, although I think it could be drafted slightly differently to make that more express. But as I read it, it says the operating agreement may also provide an alternative means, which means that the operating agreement may not.
I think that's a good point, Mohsen, because I think what happens in the situation where you do opt out and you just leave them hanging, because I think that throws them back into the uncertainty that we've been trying to avoid with our carpet layers.
Well, but so I guess a couple of responses. One is it's a may, it's not a shall. Yeah. So you can opt out of 807 and not replace it with anything. And if you do that, again, that's a contractual choice that you're deciding. So you're not being thrown to the wolves by anyone but yourself in that sense. And what are the wolves? The wolves is just litigate your claim in the courts. It's not really wolves at all. I mean, it's obviously time consuming and expensive, but you know, courts exist to resolve disputes.
I suspect bias on the wolf question, but okay.
But I agree with you, Mohsen. It is in a sense, it's not obvious. What I find it also, I personally found it difficult, and I was actually glad to be able to have some language from Rolka to steal from, to say, how do we say you can't vary it, but you can opt out? And that's where, just from last time, that the in which case clause, everything that goes after that was, there was some concern expressed among the group wanting to make it very clear that if you opt out of 807, you can contractually have whatever you want to have. So it's basically saying you can replace the statutory construct with a contractual one. But you have to, that's where I mean, it may be that you might need magic words to say, hey, we are opting out and we're not just trying to vary.
Right, and that's why I said before, is I thought, you know, the educational aspect of this for our peers is going to be really important. Yes, Teresa?
I actually like the way that this is drafted, and Mohsen, I think what it adds is it's really a direction to the court to say that you're going to apply 807 unless there's something clear in the operating agreement that says you're not going to apply 807. And if there is something clear in the operating agreement that says you're not going to apply 807, then you'll look at whatever the operating agreement says and go by that, because that's what the parties have agreed to, which may or may not be similar or different than 807 modified. But it's requiring, it's giving the court a direction. You get to apply 807 unless there's something clear to the contrary, and then just follow the operating agreement. Because Otherwise, I think the risk is that people who kind of don't really know what they're doing will write a badly drafted operating agreement where it's not clear if 807 applies or not.
So, I mean, if that's the argument for this, then I have real reservations about this language, because Teresa, what you just described is the default rule under RUCLA, right? RUCLA says there are certain provisions that you can't opt out of, and then everything other than what's on that list, you can opt out of in the terms of your operating agreement. So this should be, we don't need to say it here that you can opt out of this. If this is just another one of these default rules that you can opt out of, then we could just leave this part unsaid, because all of the provisions of RUCLA can be opted out of unless they're one of the special provisions that are considered mandatory. And to include this language in here then just muddies the issue as to whether there are other provisions that don't include this language that are really mandatory, even though they don't say they're not on the list of mandatory provisions.
From a drafting standpoint, of drafting the legislation, I understand your point on that. But isn't the difference here that here we're saying you can opt out and create your own scheme? Because most of the time people don't get to create their own, what they want their court remedy to look like in their contract.
I mean, I teach contract law in various capacities, and there's all sorts of provisions in contracts about what your remedy will be: specific performance, liquidated damages, waivers of certain kinds of damages, right? That's pretty standard contracting. So I don't think that makes this any different in that respect. I don't know. As in practice, I never wanted to sign off on any kind of contractual language that I couldn't understand myself. And here, I don't want to sign off on any kind of statutory language that I could not explain what it truly means. If it just simply means that you can opt out of this and create your own mechanism, I don't understand why this needs to exist, because that's always the case under RUCLA, unless you're one of the mandatory provisions that are identified in Article 1.
Well, I think that's a fair point. I think you might be persuading me.
Yeah, I agree. Now I'm wondering if besides the special litigation like provision and the similar opt-out there, are there other provisions in ROLCA that are specifically opt-out? I'm sort of wondering if we need this.
Yeah, the operating agreement. So I'm looking at D 105 on page 24. The operating agreement may specify the method by which a specific act or transaction that blah, 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 with duty of loyalty may be authorized or ratified, may alter provisions in 405A2 so that the prohibition requires only blah, blah, blah. I mean, I don't think it's not in C. C talks about the things that it can't. Let's see. An operating agreement may not. I think it's 105D that says that, the operating agreement can modify things. So maybe it's not appropriate to have it in C. Maybe it's appropriate to have it in D as a permissive modification.
Well, ROLCA 105C5 says you cannot alter or eliminate the duty of loyalty.
Except as otherwise provided in section D. So
right. So there's like you can't modify this unless we tell you can. And then D says, here's where the limited authority we're giving you to modify.
Right.
I think our thought on this 807 was to not limit what you can do in that regard. I mean, current Oregon law contains no limits on what you can do, essentially. And so we didn't want to limit what you can do, having added this to ROLCA either. And so maybe it is clearer just to not have anything in section 105. 105, I think that this language that we had come up with for 105C that's referencing 807 was to say, look, you've got, essentially it's a clear language requirement. You've got to clearly opt out of 807. And if you do, you can do what you want. And maybe we don't need that clear language requirement. And we can just sort of anything that touches on the buyout mechanism is a valid change.
Okay.
So Cody, without expressing an opinion, if it's a clear language requirement, then I think that this language that you've drafted could be drafted more clearly to make it express that's a clear language. I'm trying to use other words other than clear to make it express or explicit that this is a clear language requirement, because that's not exactly how it reads to me. And that's just speaking to what, if that's the intent. I would have to think further about whether a clear language requirement is appropriate for this, and if it's appropriate for this, where else it might also be appropriate, because I don't see a clear language requirement elsewhere in the statute.
I think Michael has something he wants to say.
Well, I just wonder if we could address this issue in a comment rather than an amendment to 105. If you start from the premise of freedom of contract, and unless 105 says you cannot do something in the operating agreement, you have freedom of contract to design the relationships amongst the company and the members as they see fit. And so maybe a comment under 807 that the parties are free to vary the terms of the operating agreement as it may, as you know, include opting out of 807, or otherwise, you know, I think you could pick up actually some of this language may also provide alternate means by which the company and the members may purchase the entire interest, et cetera. I think just it would be instructive to our colleagues that are drafting operating agreements in the future to have a comment.
Sure.
But as I hear the discussion, I'm not sure we need to change 105.
That's fine by me.
I like that approach too, Michael.
Okay. So with the proposal to draw, any other further discussion on this? Okay. So with the suggestion to drop some language with respect to this last paragraph into a comment, any other comments on the proposed draft? Okay. So I would like a motion on adopting this as a recommendation of this group, because this is an addition to the language that we haven't, you know, beyond what Rolka says.
Move.
Second.
All in favor? Aye.
Anyone opposed?
Any opposed?
Motion.
Okay, fair enough.
Noted.
All right. So good. Thank you again very much. I appreciate all your hard work on this. And that actually, before we move on to section 906, I did want to mention Sandy has kindly, and Sandy's team has kindly put together a pulled Rolka into a Word document. So what I think I would like for us to start doing is to incorporate our notes. Mine are all handwritten. And since nobody other than myself and my legal assistant can, it's okay. Good comment, Nosen. Since nobody other than myself and my legal assistant can read my handwriting, what I would propose that we do is I'm going to incorporate what I think the edits are into a section at a time and send them out to the group. And then to the extent that these are consistent with your notes, let me know. If they're inconsistent with your notes, let me know. But I want, when we go to Legislative Council, for us to have a markup of Rolka so that Mr. Brennan can take it and run with it, since he hasn't been able to attend the meetings himself.
And real quick, what I did with the document you'll see is that I removed all of the commentary, so it's just the language. So it's easy. And Valerie, did you want me to put it up on a cloud server so folks can edit as well?
Well,
it can be secure. It's not. It can just be accessible by these folks if you want.
Yeah, I would like us to focus on a section or two at a time, though.
Okay.
So you and I can talk offline about the best way to mechanically make this happen. But you know, we're entering the home stretch, even though we've got, you know, what, about 70 pages left in my printout of this thing. But we're entering the home stretch. And so I want us to have, going into discussions with Legislative Council, a clean draft reflecting all of the changes that we've made in our work on this project. So I think that that's going to be the next step. And we'll start that after this meeting. And frankly, after I finish writing the exam for my estate and gift tax class. So,
hey, Valerie,
yes,
instead of you having to do all of the work, would it make sense to have each person who led a section put in the changes for their section and then send them to you, and you can compare them to your notes and then send them to everybody if that's in agreement? If not, talk with that person,
would be
because
hugely helpful.
I think each person probably knows their own section better than the rest of them.
Yeah.
That would be hugely helpful.
So Valerie, I could just send, and Teresa, I could just send the clean copy to everyone. And then
Yeah.
you, okay.
Please do, Sandy.
I will.
And that way, I think that will make things a lot more efficient.
Great.
Thank you for that suggestion. Okay. Anything else before we move on to section 906?
I was just going to ask on section 801 and 806, there was some folks who were going to reach out to the defense bar and ask them a couple questions about. One was the definition of what is a derivative claim, and the other one was going to be about expert fees awardable in derivative claims. And then also there was a question about the relevant language of 105C as it concerns direct and derivative claims. And somebody, maybe it was James or Cliff wasn't, or it was Cliff who wasn't here last time, who was going to talk to some of his colleagues. And so I wanted to know, I mean, we can maybe do it a different time, but I thought if people are prepared.
Yeah, let's keep it on the radar.
Yeah, I didn't have a chance to follow up with those guys.
Okay, we can punt that.
I mean, I think as long as we get it done before we do finish our draft of it, I think it'll be fine, because I want to keep them on our radar as we're starting to think of constituents that we need to start running stuff by. James?
You ready for me?
I'm ready for you.
So Valerie, my notes say that we were almost ready to start 906. We actually were still finishing up the end of 905.
Okay, I do have brackets
specifically in 905B, we ended our last meeting in a conversation that I, of course, did not follow at all because the tax people all started talking, which means my brain immediately gets cloudy and I start to think about laundry and other things I need to do. So do we want to raise that again now, or do we want to wait for Roberta? I know we had talked about, I don't know, it's tax, it's Department of Revenue potentially. I don't know when you want to address that.
I think somebody had suggested striking B and C, and it took us down a deep nexus rabbit hole. Because the doing business question is a really big issue when you're talking about, tax presence and registering and whether that creates tax presence. So, I tend to be more in favor of clarity on this issue than ambiguity. So, I am fine with B from a tax perspective. I don't remember precisely who was upset about B. It may have been Jeff. I remember Jeff was interested in this issue too. We can circle back to this. Let's just say we'll circle back to that if they have questions.
Got it.
But I do think that the combination of B and C working together still allow Department of Revenue and, the private tax bar to have a discussion about it, because they explicitly carve out tax from the things that, are implicated by this.
Yeah, C seemed like basically what the law is today from my perspective. So I was fine with it, but recognize my depth of knowledge in this area is measured in inches. Okay, so 906. We are now talking about foreign entities and registration in the state of Oregon and what they do if they have to change their names. So 906, non-compliant name of a foreign LLC. Section A, a foreign LLC whose name does not comply with the naming requirements, Section 112, may not register to do business in this state until it adopts, for purposes of doing business here, an alternate name that complies with Section 112. A company that registers under an alternate name under this subsection need not comply with the ABN statute, which for us is Chapter 648. And then after registering to do business in this name in this state with an alternate name, a company shall do business in this state under the alternate name, the company's name with the addition of its jurisdiction of formation, or a name that the company is authorized to use under the ABN statute. So for existing Oregon law, you're going to 63.717. And subsection 1 says, except as provided in subs 2 and 3, the Secretary of State shall not authorize a foreign LLC to transact business in the state if the name doesn't conform to 63.094. So pretty similar requirement. And then I'm going to skip 717 sub 2 for a moment. Going straight to 3, if an LLC company name, corporate name, et cetera, any other existing name registered in Oregon is not distinguishable on the records of the office from the name of the applicant for an LLC company, the Secretary of State shall not authorize the applicant to transact business in this state unless the foreign LLC states its name on the application as, and then your name, followed by comma, a limited liability company of place of organization. So to give an example, if you have a Sasaki Enterprises LLC is a Delaware LLC and you want to register here, but turns out Valerie's already got an entity here, so you're blocked. You would register as Sasaki Enterprises LLC, comma, a limited liability company of Delaware. So that's current practice in Oregon. You have a very specific rule for how you must do business. ROLCA is a little more permissive in that it allows you to adopt a different name altogether and to use that as your registered name. So it's a little bit different substantively. I like ROLCA better because it's a little more flexible. And I don't think there's any real cost to that change. So I think 906A is good as written.
Jamie, do
And
you
I'm
have
not
any?
hearing anything else.
Hi. So we did have something similar to this before where a business, if it were a foreign, could use an alternate name and have that registered. Our system would have both names. So we would have both names listed. And then when that went away and we went to what we currently have, we changed our system and now we don't have that anymore. So it would be a cost for us to put that back at this point. But we definitely did have it before, and we just actually started to get to the point where we don't have this. We only had a couple left in our system, so that had both names. So that is something to think about. But we definitely had it before. It's just that we've done away with it.
Yeah, so what it would look like is it would look like if there would be Sasaki Enterprises LLC in Delaware, and then I would come here and I'd say, oh, Valerie's got Sasaki Enterprises already. I'm just going to call it, Sasaki LLC. Mm-hmm. But it would have both in the system. Maybe you'd have to keep track of both.
Right. We would have to have the name that is being used and the name that it is in the other state.
But because you currently have entities that you're still tracking with that, it sounds like the software is capable of doing that.
It is in our old system, but it's not in our new one. So there is still a couple in the database, but as far as what the system allows, we don't have that. It doesn't allow it any longer. So it's kind of in the background still, but it's not necessarily something that we can actually go in and touch and enter anymore.
Okay. Well, yes, Michael.
I was just going to make the point, and Jamie, you can confirm this, that
we lost your video.
What happened here? Sorry. That this issue is not only in the OR 63, but it's treated uniformly across the various entities. There's a counterpart in the Corporate Act 60.717 as well. It reads the same. So we get into one of these compliance things where I think it's good to have a common procedure amongst the entities so that, the staff at Secretary of State doesn't have to carve out a special something for, say, LLCs. I think at some point, maybe when we're looking to update the Corporate Act, particularly, this could be something we might want to look at. But I don't know if we should, at this juncture where it's just a a state compliance issue treat LLCs differently. I don't know if you have thoughts about that, Jamie.
I would prefer to keep things as uniform as we can. And when you start to get into having different requirements for, all the different entities, it definitely increases errors and definitely can be confusing to staff, but more importantly to the businesses. They get confused very easily when you have these changes and they're like, well, how come it's not the same for this? And you have to go in and explain all of that. But it would be nice if it were as uniform as we possibly can, or keeping things consistent, I guess I would say.
Teresa?
Does anybody know why this was changed before? Because I presume there was a reason, and maybe it was to simplify things for the Secretary of State's office, or maybe it was to avoid the kinds of confusion that you're talking about. But if there was a conscious decision to change this before, then I don't know that we have a good reason to change it back. And I would be inclined to, in this situation, keep the existing Oregon law regarding how naming works. Partially because I don't think it's worth adding a cost to the bill. Whenever we add a cost to the bill, we're going to decrease the likelihood that this thing will get approved by the legislature. And I don't think this issue is where I want to have that fight.
And I think, Teresa, you look at the dates of these provisions, it's very, if not identical to the Corporate Act 60717. And it was adopted 1993, which was when the LLC Act first came into Oregon. So it looks like it was just simply copy and pasted over from the Corporate Act. That's really the history. So the legislature, I guess I read into that they wanted uniformity, like Jamie is talking about.
Does anybody feel strongly that we need to adopt the Rolka version over the Oregon version with respect to this naming issue? I hear crickets.
Well, I have a question. Isn't the only, or tell me if I'm wrong, but as I was following the bouncing ball with what James was talking about, it seemed like 906A 1 and 3 are like the bonus you get under Rolka that you don't currently get under Oregon law. It seemed like A2 was pretty similar to what Oregon is currently requiring. And so I guess, am I wrong in restating the question as should we get rid of A1 and 3?
No, I think that's a good point, because I do think the way that 63717 is drafted is a little bit weird.
I don't think that's actually exactly what's going on, because it's really just what is the base filing that the foreign LLC submits. Right. I think you can still accomplish the same objective by registering as Sasaki Enterprises LLC, a limited liability company of the state of Delaware, and then you file an ABN for the name that you actually want to use. So you can still get there. Rolka would have just allowed you to combine what are currently 2 filings into 1 filing.
Right, but I think the question is, if we struck 1 and 3, does that get us to substantially the same place as 63717 sub 3? And I think it does.
I think we would strike only 1, because you could still register an ABN.
Oh yeah, if we strike the brackets around it, right?
Yes.
Yeah, that makes sense. Does that sound like a reasonable edit?
Yeah, I think so. Just so we're all clear, we would also have to modify A to reference that you're not adopting a name, and we would track the existing language in the ORS for what name you register under.
Okay, so how would you change A language-wise? So it'd be that a company that registers, right? We'd need to edit.
You'd say something like a foreign LLC whose name does not comply with section 112 must register under the name and then copy the language from 717 sub 3. Name under which organized, comma, a limited liability company of place of organization.
Mm-hmm. Okay.
And then you'd probably keep for the purpose of doing business in this state, and then you would strike an alternate name that complies with section 112.
Okay. And then we would also strike that next sentence, right? Because they would need to comply with the ABN statute if they're going to register an ABN.
That's correct. Yeah, that second sentence comes out.
Okay. Okay.
And then the third sentence would be modified a little bit because you wouldn't register with an alternate name.
Mm-hmm. So just strike with an alternate name.
Yep.
They shall do business under their name with the addition of the jurisdiction. Yeah, that looks good.
Okay, so going back to 717 sub 2, which is the subsection I skipped over. This basically allows you to not use LLC or limited liability company or whatever the magic words are in Oregon. If you use the magic words of the foreign jurisdiction, there is no analog under ROLCA. You just need to comply. And I think that makes sense, including the way we're modifying this section to allow you to register or to force you to register under your home jurisdiction's actual name. So I don't think we need to preserve 717 sub 2.
Mm-hmm.
Okay, and then going to 906B. If a registered foreign LLC changes its name to one that does not comply with section 112, it may not do business in this state until it complies with A by amending its registration to adopt an alternate name that complies with section 112. The parallel is in 717 sub 4. Foreign LLC authorized to transact business in the state changes its name to one that does not satisfy the requirements of this section, may not transact business in the state until the change name, under the change name until it adopts a name satisfying the naming requirements. I think we would need to make modest changes to B again, because we're not necessarily adopting an alternate name that complies with 112. We would probably just reference the naming or the registration under A.
Mm-hmm.
Wouldn't you just delete the phrase to adopt an alternate name? You can't do business until it amends its registration to comply with section 112.
I think you need to add that, but yeah.
Yeah.
Cool.
Okay, that's 906. Any other input on that one?
The only thing I was curious about, I don't know if anyone has experience with it, but it seems like there's a lot of LLCs set up to handle franchise operations. So they're actually doing business as a Burger King, for example, and that's their signage. And although they have the specific name of the LLC inside the business, it's still really doing business as Burger King. Have you guys seen any other states that have a process for recognizing the company's ability to do business essentially under two names?
Interesting.
It's just kind of, well, I've always been curious about it, frankly.
Mm-hmm. Yeah, I don't know.
I've never seen an elegant solution, but I know it hasn't stopped, obviously, all those individual franchisors across the country.
Yeah, and we don't do that much with franchises. Does anybody know someone who's a really good franchise person? Okay, I will reach out and try and find someone who's a really good franchise person, because I think that's an interesting question. And I think you're right, Cliff. I think we are like the McDonald's down the street from me is something K, like K&K LLC, right? But it's the McDonald's, and so it's all their McDonald's signage and stuff. Yeah.
So anyway.
Maybe I'll send an email to the business section list and just see if it pulls anything interesting up.
Yeah, it almost seems like, I don't know, if there should be like a franchisor exception or something in the statute that still allows them to operate that way, as long as inside the walls they do differentiate or clearly identify the LLC name under which they're operating, something to that effect.
Yeah, it's an interesting point, right? Because clearly they're not all owned the same.
Not at all.
Okay, no, it's a great question.
Not one I have an answer for, though.
Me either. I mean, I'm sure someone does. Someone must, right? Jamie, do you have any thoughts about that actually? Because Secretary of State would be the sort of the first port of call.
Sorry, I was just looking something up to see what information I had about franchises.
Yeah.
And so Oregon is one of the few states that does not register or file franchises. However, we cannot say whether or not the business should file a business registration with our division. Some do and some don't. It depends on the agreement with the franchisor. Let's see.
So I think you're referring to the FDD, the franchise disclosure document.
Yes.
As opposed that they'd write it, like Burger King would file that with California. I guess they may not do that in Oregon, but I don't know if that would dictate kind of the naming issue we're looking at.
Yeah.
Yeah, I'm just reading out loud here. It says one way a franchise might be filed for a business entity to be a franchisee of the larger franchise. For example, Acme Restaurants, Inc. might be the franchisee owner of a local McDonald's franchise. Acme Enterprises, Inc. would be registered, McDonald's would not.
Typically, so I think how I've seen it in lending relationships when I've seen loans to franchises is it's always done in the name of the actual entity and not in the name of the franchise itself, the McDonald's or the Burger King or whatever.
Right, and they're not registering a DBA for McDonald's or whatever.
But they're from all perspectives. If you're outside the restaurant, you see McDonald's or Burger King or Arby's or whatever it is.
Right.
The Division of Finance and Corporate Securities is who regulates sales of franchises in Oregon.
Yeah, but not the
actual filing of them.
Right,
sorry, one of my random questions. Maybe we can just see if anyone else has anything outside the group.
For what it's worth, Cliff, I looked up McDonald's on the Secretary of State's website and I see a whole bunch of ABNs for McDonald's of Independence, McDonald's of Lincoln City, McDonald's of Roseburg.
They are registering ABN.
Yeah, they can register for sure.
Interesting.
But it doesn't look like they're required to.
I have a question or a thought about this. One thing that we haven't mentioned is statutes outside of ORS 63 that might get altered by what we're doing here. Right. And I've never dealt with our fictitious names statute. So I was looking, for example, at 648.081, which among other things says, a foreign or domestic LLC may register as an ABN its LLC name minus the word, abbreviation, or phrase that ORS 63.094 or 63.717 requires. And obviously that will have to change if ROLCA gets enacted. And I guess I hadn't even thought before about searching through all of ORS to see all the references to 63. Whatever and what might need to get changed. And I'm sure Legislative Council is going to be on that, but I don't know if there are going to be any, this seems procedural, just redirect the citation, but I don't know if there's any substantive changes that are in other statutes that we want to worry about.
Well, I think it might be helpful for Sean as we're going through and flagging, in our own sections on the markup, if we would flag sections that we think are probably implicated. That we haven't discussed. Because I don't think we have to discuss everything, because I think you're right. Things like this just need, updated reference. But, you know, at least that way we'll have looked at it.
That will be a big task for somebody.
Well, hopefully it's just redirect. I mean, I guess this is maybe just a question of process, but when we give this baby off to legislative council and they do their thing, they'll comb the rest of the RS. And,
Yeah, they will, and they've got software and stuff that cross references everything.
Okay,
And
so then
but-
we can go over it at the end and
Yeah.
decide if there's anything substantive that we want to deal with at that time.
But to the extent that, you know, you've noticed things as you're going through and working on your sections, I think it would be helpful if we could flag that for them too. If only to say that we didn't talk about this.
Because Cody, one thing that I've seen with other bills is that they might come back with something that was related to another section, but then we can go back with them if they misinterpreted or if there's something like that. So if we keep our notes centralized, like Valerie said, it'll help us in that negotiation later on.
Okay, cool, thanks.
Yeah, they're pretty good about picking up all the cross references everywhere else in the code, because we went through that process on the receivership group where they had to change all kinds of other sections throughout ORS to fix cross references, and it turned up a few things that we needed to talk about. So it was a good part of the process.
Good.
Okay, cool.
That's helpful to hear too, Teresa. Thank you. Anything else on 906? All right, I just turned the page. 907.
All right. 907, 908, we're getting into some sections talking about basically changes to your foreign registration. If your entity is undergoing some kind of change, what happens to your registration? I don't believe we have similar provisions in current Oregon law. I'll be interested, Jamie, in your input in particular on whether this is basically what's happening anyway, or whether this is a change to existing law. I suspect this closes some loops that are currently not really addressed as clearly as this would. So I'm guessing it's an improvement, but we'll see. So 907 says a registered foreign LLC that converts to a domestic LLC or to a domestic entity whose formation requires delivery of a record to the Secretary of State for filing is deemed to have withdrawn its registration on the effective date of the conversion. So obviously, if Sasaki Enterprises converts from Delaware to Oregon, it doesn't need to be registered as a foreign entity here anymore. So the conversion documents in and of themselves affect a withdrawal of that foreign registration. Jamie, does that?
And it does. So just reading over it. So currently, if we do a conversion and we have a registered foreign limited liability company that converts into a domestic, then they would still be active here. So it's all, they keep the same registry number, everything stays the same. And then sometimes when they're converting out is how we usually would word it. If it's a domestic that's going into a foreign and they don't want to be active here, then we have a transaction so that it makes them inactive during that at that time. But they still have the option to be active here if they want to. So we can do it one of two ways.
Right. So a finer point that I'll just call out in section 907, you see this reference to domestic LLP as additional to any other entity whose formation requires a filing with the Secretary of State. I don't deal with partnerships a lot. I think what's going on here is that a partnership can exist under common law without any filing, right?
Mm-hmm.
And it's really the filing that turns you into an LLP. It doesn't create you. It doesn't mean that you now exist. It just means that you now have this limited liability shield. And so I think that's why they couldn't just say any entity whose formation requires a filing with Secretary of State. They had to specifically call out an LLP as different because it's different.
Makes sense to me.
So just to, I guess, we don't require domestic LLPs to file anything with the Secretary of State?
A partnership, no. A general partnership, no. If you want the LL, if you want the limited liability protection, then you do have to file a statement with the Secretary of State, but it's not the equivalent of articles. It's just It's a document that gets you the limited liability protection. It doesn't create your existence.
But I guess my question is like the way that, because I don't read Rolka to make that distinction that you just enunciated. Rolka talks about, and I guess an entity whose formation requires, so you're saying that the formation of an LLP occurs without regard to any filing with the Secretary of State.
Yep. And that's the only reason it's not otherwise picked up by the rest of that sentence.
But you cannot have under Oregon law, LL. I mean, I guess it begs the question in a sense, what is formation? Like if you don't get the limited liability, then are you really a limited liability partnership without your filing? But because we're requiring any would-be LLP to file in order to have the LL, then there's still going to be a public filing when a foreign LLC becomes a true domestic LLP.
Yeah, there will still be a filing, but I suppose it could convert to a general partnership and not have a filing.
Right. Although if they do that, at least under 907, they're not automatically withdrawn.
Yeah, I think that's right.
Okay, cool. Thanks.
I think the confusing thing about this is that they wouldn't automatically be withdrawn, or I don't. And maybe it just is the way that it's reading to me, but they could still be, the registry number and all of that would still be in existence. It's a paper trail that shows basically that they used to be a foreign and they've converted into a domestic. Doesn't necessarily, I mean, it does mean that the foreign's no longer, but the actual business itself is still there. Does that make sense?
Yeah, but I guess just I'm trying to, part of me is understanding what is the point of 907, and it's giving you this sort of automatic withdrawal of registration as foreign LLC in certain circumstances, and which doesn't include transitioning to a domestic general partnership. And I guess if you were to do that, who does, but if you were to do that, then I guess you're going to still be registered as a foreign LLC until you actually file a document with the Secretary of State. I don't know what the negative consequence of not filing with the Secretary of State would be, but anyway.
It is a weird little gap in my mind that I don't fully understand. I think what this is trying to accomplish is just sort of saying it from the other direction. If you have an affirmative filing in the state, either an organic articles because you've converted or an LLP statement because you are an LLP, then your foreign registration automatically goes away because your affirmative filing replaces it. That's the part that makes sense.
Yeah, I agree. Yeah, cool. Thanks. I just was, now I understand it better.
Yeah, I don't think including it hurts anything.
Okay, so 907 as is, 908, similar concept, but now we're talking about conversion to a non-filing entity. So registered, I'm sorry, Cody. I got so focused on that section, I didn't point you. The next section is going to address it. Oh, sorry, okay. I got up very early this morning to remind myself what I was doing here, and it's obviously catching up with me. So 908. Withdrawal on dissolution or conversion to non-filing entity. So a registered foreign LLC that has dissolved and completed winding up, or has converted to a domestic or foreign entity whose formation does not require the public filing of a record other than an LLP, shall deliver a statement of withdrawal to the Secretary of State for filing. So if you're converting to a non-filing entity, you're going to file a withdrawal. The statement must state, one, in the case of a company that has completed winding up, your name and jurisdiction of formation, and that you surrender your registration to do business in this state. And in the case of a company that has converted, the name of the converting company and its jurisdiction of formation, the type of entity to which the company has converted and its jurisdiction of formation, that the converted entity surrenders the converted company's registration to do business in this state, and revokes the authority of the converting company's registered agent to act as registered agent in this state on behalf of the company or the converted entity. That's a mouthful. And D, a mailing address to which service of process may be had under subsection B. So if you're winding up, or if you have converted to a non-filing entity, you're going to withdraw your registration. And then under B, after a withdrawal has become effective, service of process in any action or proceeding based on a cause of action arising during the time the foreign LLC was registered in this state may be made pursuant to section 119. And by way of preview, there is a change in Oregon law in ROLCA if we adopt it, and I'll be curious to see what folks think. Some of the practitioners are probably familiar with the concept that a foreign LLC is sort of deemed to have appointed the Secretary of State as an agent for service of process in certain circumstances. ROLCA does away with that and just points everything to section 119. I'm confident the litigators will have stronger opinions than I do about that, so we'll get to it when we get to it. But for purposes of this section, I'm just observing that you're going to give the Secretary of State a mailing address where service of process may be had, and that's where service may be had under B. So if we end up going the Secretary of State route, we'll need to come back to this to potentially change it. But I do think that conversation might be better.
Well, we talked about section 119 before. I think we were keeping the ORS language on service of process on the.
Yeah, I remember a particularly long discussion on this topic.
Yes.
Did we talk about it specific to foreign entities? Did we talk about it? Did we talk about it specific to foreign entities?
Well,
I'm not sure if we did. I think we did, because 119C talks about if process notice or demand cannot be served on an LLC or a registered foreign limited LLC pursuant to A or B, you can proceed. It talks about how you do that. So I think the idea is that we wanted to maintain Secretary of State service on all LLCs that were registered with the Secretary of State, whether they were foreign or domestic. And I think strongly that we need to continue to do that.
I agree with that wholeheartedly.
I remember this discussion. It's coming, it's coming back.
I strongly welcome not revisiting that conversation if we've already got a decision. So if that's the case, then we probably need to fix sub D and then B to talk about service of process and deemed appointment of the Secretary of State.
Well, I thought that was B just points you to 119.
Yeah.
And then so you just look to. I don't think we need to change 908. And then 119. I thought we had decided that, or I thought 119 already covered the registered foreign LLC. And so in other words, I don't know that we need to make a specific change as to.
No, I don't think so either, because if you look at C on page 54.
Yeah, I mean, I guess we had, I guess, because, well, maybe we need to, because 63, 121, 3, 4, and 5 is where we were getting the language.
Okay.
I don't think 63, 121 talks about foreign LLCs, because ORS chapter, 63 dot, 727, it's ORS stuff that we haven't gotten to yet. It's what talks about, it's 63, 731 is like, that's the service on a foreign LLC. And that 63, 731 is like somewhat the counterpart to 63.121, which is for domestic LLCs. And we had pulled in to section 119 language, this relevant language about making the Secretary of State your agent and how you serve through the Secretary of State. And we had basically put a placeholder for 63, 121, 3 through 5 and adding that to 119. And I think if we just change the references and the relevant language to foreign or domestic LLC, then I think we've got the issue resolved.
Yeah, I think legislative council can figure out whether to incorporate both 63-121 and 63-731, or whether it would make sense to combine those and streamline the language. But I agree with you, the concept that we need to include the stuff from 63-731 back into section 119.
Yeah, I agree.
Yeah, I think it's substantively the same,
I
essentially.
think it is.
I think that the only thing that I think doesn't really get covered is the foreign LLC that does business in the state without registering in the first place.
Mhm.
And I don't know whether we want to have them be deemed. I think 63.731 talks about what you do in that scenario. And
yeah, I'm just adding a note that to include language from 63-731. And I think probably we've done a lot of we made a lot of changes to Article 1, and it wasn't assigned to anybody in particular, just because it looks like we've just been, dealing with it as we've been going along. So I don't think it was assigned to anyone. Jeff, Michael, was that wasn't one that you did with Jeff, was it?
I'm looking at our initial list, and
Yeah, I have you guys on Article 2, and I don't have anybody on Article 1.
the initial list I have had Jeff and I as Article 1 folks as well.
Okay.
that's what my
but
note is.
I would point out that at least 119, and I don't think we changed this, refers to a limited liability company or a registered foreign limited liability company. So the introductory language in 119 covers both when you're looking at the service of process issues. And I don't think we changed that.
No.
I'd have to look back at the notes to see exactly where we did leave 119. I do remember a very long discussion.
Yeah, I don't think we have anything on. Yeah, it's coming back to me. I think, yeah. I don't think we talked about 63-731 in there. Although foreign entities are particularly, addressed, because if you look at the subparagraphs to B, they mention foreign companies, right? But I think, just to make a note saying that, we do want to include the language from 63-731 as it makes sense, I think is appropriate there. So I think our conclusion was that we just don't intend to change the Secretary of State's process there.
But isn't 908 fine in that it 908B just takes you back to 119?
I think it's fine because it just refers to.
So I think, we deal with 119 as covering both domestic and foreign LLCs.
Right.
I think that's right, Michael. The question I would throw to legislative council is whether we need any changes at the bottom of A, 2, C, and D. C talks about you're revoking your registered agent in the state. Do we want deemed appointment of the Secretary of State there, or is that covered somewhere else? And then D talks about providing a mailing address where service of process can be made. The litigators may have a view on that. I don't know if you want an additional address, and then is it confusing whether you are using your deemed service on the Secretary of State, or would you just rather have more addresses so you have more ways to serve?
Well, under 119, there's a waterfall, and your first stop is the registered agent, basically. Right. And then the second stop is, sort of this address that that they gave you, which, would potentially be the address that's covered in 908 that they're required to provide. And then if you can't do that, then you can do any address that you're aware of. And then finally, if you can't do that, that's when you go to the Secretary of State. So I think certainly there's no harm in having this language in D, 908D be the same. And I think that in terms of 908C, when they convert, the new entity is going to be giving you this new registered agent, all that kind of stuff. And that's fine that they revoke the authority of their of their sort of designated registered agent. But you're right, I don't think we want them to be able to revoke the Secretary of State. But I don't think the Secretary of State is labeled as a registered agent under 119. I think it's just sort of statutory agent.
Yeah, I was just, whoever's cleaning up the drafting will want to think through, we've got a clear revocation of the registered agent here. Do we want to reference or cross-reference the deemed appointment of the Secretary of State? And I may be using the wrong terminology, but the point is you've got half of it here, not both pieces.
I think we flag that for legislative council and let them decide where they're going to want to put it, because they will have an opinion.
Yeah,
I agree.
Always add a comment saying that C doesn't revoke the appointment of Secretary of State as agent.
Mm-hmm. Cool. So do people want to take a 10-minute break? Looks like we're at 10:30. We'll take a 10-minute break and come back at 10:40 or so.
Yep. I'll pause the recording.
So walking through those in 63.707, I think we already talked about adding clause C, which is the registry number in the state of formation. One that we said we would come back to would include, I think the next one was, I'm sorry, D as in dog. So the date of organization and a statement of whether it expires or that it's got perpetual duration. I think we were leaning toward adding that one. I'm sort of raising an eyebrow, see if the group agrees or disagrees.
Yeah, my notes say that we were going to keep D and H simply because not all jurisdictions have adopted roll call. And we were going to ask the Secretary of State about whether we should have G.
Yeah, okay. I had H as also on the question list, but I think we were certainly leaning toward that. So G, Jamie, is the statement that your LLC complies with 63.714.3. And actually, I'm not sure. I think we were talking about having something similar because that section, of course, would go away. There's currently a requirement in Oregon law when you register to say that there's no difference in my state law that prevents me from registering here. There's a specific statement included in the Secretary of State's form. So I guess the question is, do we want some kind of carryover parallel where somebody's making a representation that the foreign jurisdiction's law is not inconsistent with Oregon law? My own view is that you can't get any powers in Oregon that Oregon wouldn't allow you anyway. So it's sort of, in my view, redundant, but that was the question.
Yeah, it does seem a little redundant. I don't think it hurts to keep it there. I was just gonna go back and look at the form really quickly and see.
Yeah, I pulled the form last month and I laughed because I had never seen that statement in there. As many of these as I've completed and filed, I've never noticed where it says we are complying with 63.714.3.
Right, that's what I was trying to think. I'm thinking, where is that at on the form? Because I know the form's pretty well.
Didn't you say it was in the fine print, James? Or
It must be.
It's like paragraph 4 or 5. It's a paragraph where there's nothing to fill out. It's just a statement. So you can't really get around it. You wouldn't be able to delete it, for example.
There it is.
Maybe that's more for the clients than us lawyers.
Yeah, and probably more for them than us at the Secretary of State. But when it's included in the form like that, it's just so that way we don't have to have them check something off and then have to reject for it. So as far as
Sure.
filing is concerned. I mean, either way is fine to have it or not, but it does seem like it's just saying that they do comply, and it might be a bigger picture for someone else.
Maybe on policy grounds, it's in there. I mean, we
Mm-hmm.
deviate from policy.
I think that it's probably just so that they can basically say that they meet all of the requirements that that we have by registering.
Well, it's really, I think it's a statement that the law of your organization, your jurisdiction of organization does not conflict with the Oregon
Mhm.
LLC Act. I don't know. I don't feel all that strongly. Again, because I think you only get what powers an Oregon LLC has anyway. I don't
Mhm.
know that it adds much, but if folks have strong opinions on it, then maybe we ought to just import everything in 707 that's not in ROLCA.
I'm trying to figure out what sort of the substantive impact of this is. So if this is a LLC that's formed under some foreign country where, you know, a particular drug is illegal that you can't sell in Oregon, but they're perfectly fine to sell it in, you know, Upper Slobovia. Does that mean when they come here, they're agreeing they're not going to sell their illegal drug here? Because if that's all this means, then I don't see any harm in keeping it. If it means something different, I guess I'm not sure what that would be.
Well, the substantive limitation is in ROLCA 901C anyway. You know, that's the equivalent of 63.714.3. And so even though some other, maybe drugs isn't the best example for what's prohibited in Oregon, but
Trying to think of something extreme, but
yeah,
other
nuclear weapons. Maybe you can do the nuclear weapons in Idaho, but you can't do them in Oregon. And so I think it's clear you're not going to be able to sell your nuclear weapons in Oregon, even if Idaho lets you do that. And we've already got that restriction in ROLCA. This is just a question of whether your registration statement needs to make you promise that regardless of what Idaho says you can do in Idaho, you're not going to be selling your illicit goods in Oregon under Oregon law. And that's really, I think, the question. It's not whether we should have this sort of substantive clause. It's just whether this should be part of the boilerplate language on this registration statement.
Well, I'm gonna push back a little bit. And again, this was that section that I called a little wonky last month. If you look at 714 sub 3 and what it actually says, it's a limitation on the power of a foreign LLC. It's not a certification. It's not an assurance. It's not the LLC saying anything. It's simply a statement that the foreign LLC can't exercise powers that it wouldn't be able to exercise as an Oregon LLC. And so to me, 707G, a statement that the foreign LLC satisfies that requirement, what does that even mean?
See, again, I approached it from, is it really meant to be noticed to the clients, the people who form these things, to put them on notice that there are limitations on what you can do in our, because I agree with you. Why else would it be there unless it's sort of a notification factor because of the importance of it?
Well, but 901C is already that notice, I think. That's the site Cody just gave.
One thing is other states allow for you to have a professional limited liability company. And when they come to Oregon, they can't register as a professional limited liability company. They can only register as a limited liability company. So it almost seems like it's saying also that even though you're labeled as this professional limited liability company in the other state, you still in Oregon only get to follow what Oregon says you can.
Right, and I think that's the effect of 901C and what 714.3 says, but I don't know what the point is of 707G.
I'm wondering, like, theoretically, there's some enforcement action that the Secretary of State brings because somebody's selling their locally illegal product and relies on you. You swore to it under penalty of perjury or something like that. And therefore, we're going to either bring a criminal thing against you or, you know, some other. That's where I can, like, hypothesize readily what the purpose of this G requirement is. I don't know if the Secretary of State relies on this clause in its statement.
No.
Cody, I was actually wondering if it was more of a litigator's tool to hold the signer of the filing personally liable.
Because they've promised, or I guess they've averred that they aren't doing this stuff.
Correct. So if they are, then you can hold that person. And again, hypothesizing here, but that was where my head went.
Right. Well, I mean, I do like that you are holding in high regard the litigators' abilities to find ways to strengthen their cases.
Please do what I have to do a lot during these calls.
I'm trying to think, what would the claim, I guess a fraud or misrepresentation, if this caused harm to somebody, maybe. I'm trying to think like what the fact scenario is. I did business with the LLC on the understanding that it was doing things that were legal in Oregon, but it turns out they weren't. And now I've gotten caught up in some criminal investigation. And if only the registrant hadn't lied to me about the firecrackers being legal in Oregon, I wouldn't be in this trouble. I mean, theoretically, but that same statement could have been made orally or in any other form. I guess this maybe has extra weight because it's in writing and and filed with the government. But I'm hard pressed to come up with realistic scenarios where the civil litigator is going to use this to bolster their claim against whoever signed the statement or authorized the statement to be filed with the government.
Maybe. I know in setting up certain companies, well, even cannabis companies, it's always something we consider. People are looking at Delaware, right? Delaware, you can only start an entity there for purposes that are legal in that state. So could you have a cannabis company there? And if you did set it up to like the Delaware Corporation to be selling cannabis because it was set up for a non-legal purpose, would that essentially nullify the limited liability shield?
I don't think so. I invite Aurelia or Kyle or anyone else to comment, but I don't think just because you have an incorrect statement in your document that's going to automatically result in liability to a civil plaintiff. You still would need to have a cause of, what is the claim and what are the damages resulting from that?
Well, and who's the claim against? Is it against the LLC that stepped out of authority to do something? Or is this piercing the veil and you can now essentially, the LLC doesn't exist and you can now hold the members liable for it?
That's where I was looking more the latter, because it was set up for an illegal purpose.
Or it engaged in an illegal purpose. Let's say it was set up for legitimate and it steps out of bounds. Same question though.
Right, but here I think the question isn't, is the company or its controllers liable for having engaged in conduct in Oregon that's illegal in Oregon? It's, does this statement, this boilerplate language in their registration statement being false, create a claim?
Looking
at the cat.
Your cat is great, Aurelia.
Aurelia, you got like a big staring competition there.
I think it's
quite entertaining.
Yeah, she's really into it today.
So, I mean, I think we may be overthinking this. If you look at 63.714 sub 2, it reads like it's being sort of prophylactically constitutional, right? And under sort of a privileges and immunities sort of state law sort of perspective. And so I think that's all they're saying is that, even just because their state law is out there and their state law may be different from our state law, we're not going to deny them the ability to register. So I get all of these sort of concerns about, what does this language actually mean? And I think that, at least we have found in the tax statutes that there are some things that the legislature just added on advice of counsel that were intended to avoid a constitutional fight down the road. And so I'm wondering if this language may be part of that. I don't think it hurts anything to have G be included in whatever we have, if we're including the other things that we currently have. Where I'm a little bit more concerned is whether we need H, because H, if we're moving to more of a parent authority model in Oregon, wouldn't we be requiring the foreign company registering to file their certificate of apparent authority to the extent that they want to designate people to be responsible for things? I mean, that's my concern more than G.
I'm personally agnostic about D, G, and H. I don't care. When we had discussed before, I thought that the group's consensus was D and H were being kept merely because many jurisdictions haven't yet, or maybe never will, adopt.
That makes sense.
And I thought we had talked about adding a comment to that effect in section 903 or after 903 saying we're only keeping D and H for those jurisdictions that have an adopted roll cut.
Yeah,
and even then we probably need to modify at least H because a roll cut jurisdiction won't say whether it's member or manager managed, or at least its article of organization won't. But G, I guess I had understood our analysis to be like, whoa, this seems like something the Secretary of State maybe cares a lot about. Let's ask them.
Yeah, and I have that note in there.
Yeah, they don't seem like Jamie seems to be representing this. They don't care.
Yeah.
I'm fine to get rid of G. I don't know is there an advocate for G here?
I don't think so. Good. Let's get rid of G.
How about H?
Well, Cody's point, I think, is well taken, that as a transition with other jurisdictions, it makes sense. But I do think that we should modify it to say if they have, if they have if they are a member managed or manager managed in their home jurisdiction, and that's meaningful, then I think that makes more sense. But I still think they should file a certificate of apparent authority.
What's the certificate of apparent authority? I thought that. Go ahead.
It's the document where we basically have the LLC says these people are authorized to do these things.
I thought that was voluntary even for domestic LLCs.
And it was also meant to put limitations on authority sometimes.
Yeah, but moving away from our current manager managed and member managed model to more of a, okay, these are the people that are authorized to do the things, right?
Yeah, maybe we just sort of add as a preference if the local, what if the foreign jurisdiction has an adopted roll cut, then you have to tell us the D&H information as well. Something like that. Something like that.
Yeah, I don't think it's whether they've adopted ROLCA, but it's whether they maintain a distinction between member managed and manager managed. If they still maintain that distinction, then they would need to tell us.
Yeah, at least as pertains to their articles of or certificate of organization.
Right.
Right.
Okay, I think that makes sense. So the last question coming out of 707 is the requirement in sub 2 that you provide either a certificate of existence / good standing, or if you're from a state that information is readily available online, you don't have to do that. And I made the case as best I could. Maybe Cliff will knock down some opposition with me. I made the best case I could that this is a waste of money, and we end up giving a bunch of money to Delaware to create these good standings that are just a snapshot in time, and they don't really add value in my view, especially when all my clients come to me at the very last minute and want to file something today. But other folks seem to think there was some value in having a certificate of existence so that we know that an entity isn't just completely made from someone's imagination when it registers here. So we flagged that also, Jamie, for Secretary of State input.
I would like to keep that. I know that it's only a snapshot, but there are so many times where a business they will try to do an application for authority with us, but they're not registered in the other state, or they think they're registered in the other state and they're inactive or things like that. So I feel like it's something that I would like to keep, just because it is an extra way for us to make sure that they are truly registered there when they register with us.
Can I ask, is this a revenue issue as well? I mean, is there a fee paid for getting a certificate like this?
Yeah.
It's the
Yeah.
fee to Delaware or to the other
Yeah.
state, not to Oregon.
Yeah,
It's a fee to the other state if they don't have it on their website. So there's only a handful of states that don't have the information readily available. Most states we can go and we search their site and we make sure that they're active, and they never have to give us a certificate in those cases. But Delaware is one that they have to pay for.
And with Delaware, Jamie, the state does accept it's like a less formal letter of status, right?
With Delaware, they have someone can go and they can pay online, and basically it looks like a screenshot of showing that the business is active there. But so there's the two different options, but we still have to have something from them, and there is still a fee to Delaware for sure.
I'm curious, if submits an application and submit the certificate of existence, go check online to verify, because the certificate is 50 days old.
If they provide a certificate of existence, especially like with Delaware, we can't look online to see that they're active there because Delaware doesn't have that information available.
Okay.
But most generally, we don't have to have a certificate because a lot of most states have it available online, and we just go online and we look and everything's good.
So that's really subsection B. So we would include 2A and 2B is what you're looking for, the whole subsection.
Yes.
Yep. Okay.
James,
that was all I had for going back to 903.
Before we move on, James, just to verify on subsection 1, it's C, D, and a modified version of H that we're going to include, and we're not including G.
Yes.
Well, and modified D and H, because D and H are both only of foreign jurisdiction, says that information in their certificate or articles of organization.
Okay.
That's a good point, Cody. Okay, are we ready for 909? So this is transfer of registration. Currently, under Oregon law, when you want to transfer, you just file 2 documents at once. You file the withdrawal of your first entity, and then you file a new application with your second entity, and you submit them together so no one can squeeze into the gap between them. ROLCA provides a mechanism for doing all that through one filing. So 909A, when a registered foreign LLC has merged into a foreign entity that is not registered to do business in this state, or has converted to a foreign entity required to register with the Secretary of State to do business in this state, the foreign entity shall deliver to the Secretary of State for filing an application for transfer. Application must state the name of the foreign LLC before the merger or conversion, that before the merger or conversion, the registration pertained to a foreign LLC, the name of the applicant foreign entity into which the foreign LLC has merged or to which it has been converted, and if the name doesn't comply, an alternate name that is adopted. Under the 906A, the type of entity of the applicant foreign entity and its jurisdiction of formation, street and mailing addresses of the principal office of the applicant, and if the law of the other jurisdiction requires it to maintain an office in that jurisdiction, the street and mailing address of that office, And 6, the name and street and mailing addresses of the applicant foreign entities registered agent in this state. So when you're converting or merging, this will facilitate a transfer of your registration. I don't know that I can detail them all right now, but I think we'll need to make parallel changes that we made in the other sections, because this will effectively be like a new registration. So if we have to identify duration, for example, you would need to do that here as well. But conceptually, I don't have any objection to this structure of allowing a transfer of registration.
I agree. I think we'll want to make basically conforming changes to this, like you were just mentioning that we made to 903.
Yeah, we had adjusted one of those subsections to talk about the registered agent, where it used the word office as an example. That's the kind of change we'll need to make here to conform. And as another example, in A3, we don't necessarily have an alternate name that's being adopted. We're probably sticking with the current Oregon structure. So a number of changes, but nothing terribly substantive. And then B, when an application for transfer of registration takes effect, the registration of the foreign LLC to do business in this state is transferred without interruption to the foreign entity into which the company has merged or to which it has been converted. That's probably what you all expected. Any other comment on 909?
Jamie, I'm sorry if you said this already, or sorry, James. And I think maybe we want input from Jamie. Did you already say, James, whether there's a mechanism like this under the existing LLC statute?
There is not anything express in the current statute. I think what we typically do is file a withdrawal of one of the withdrawal of the existing registration with an application to register at the same time.
So then the question I have for Jamie is, Jamie, is this would essentially be a new filing with the Secretary of State, if I understand it correctly?
It would be a new filing. We would have to have a new form for sure, and then it looks like we'd probably have to have some changes to our systems.
Okay, so the question then in my mind is, James, it sounds like there's already a pretty simple procedure to do the same thing. It just requires 2 filings, and whether that's simply this cost savings of going to a one filing system is worth the additional burdens that it'll put on the Secretary of State to facilitate this new filing.
Jamie, would the change be enough to put a revenue mark on the bill? I'm just curious.
It might be a small one. I'm not totally sure how. It looks like it probably would just be a transaction. I don't think it would be a huge increase. The only and then as far as the forms, we just have to not only create the one form, but we end up having to create 5 additional forms because of the different languages that we have to put them all in. And so there's a cost to those, but I still don't think it would be a huge amount.
Thanks.
Is that something that you would end up being able to charge fees for so that you would offset that cost? Or do you think it would be a net increase in cost to the Secretary of State?
It would be a charge. We would probably charge their $275 like we would with any other foreign type filing.
Is there a charge to withdraw currently?
There is.
So you're going from 2 filing fees to 1.
If they, a lot of times what we do is if someone it's the same business name, then we waive the fee to withdraw the one, and then they only pay the fee to start the new one.
Okay.
And we do that with all business types.
James, I actually like the simplification this offers, but I was unaware of this being used by any other states. Did you by any chance notice if any other states are utilizing this transfer?
I didn't look.
Registration?
I did not look. I like it primarily because when we do the double filing, we pretty much have to use a correspondent like Unisearch or somebody else, because we can't, like, you don't want to just drop that in the mail and hope for the best, because the first filing, right, it has to be in sequential order. And if somebody just processes it backwards, the the new registration will get kicked back. So I like it because it saves us from paying Unisearch a bunch of money, but I don't
Yeah,
feel
it
that
sounds like
strongly.
an improvement as long as there's no objection from the Secretary of State.
I don't see an objection at all. I do have one quick comment though. We are pretty good at making sure we keep those things together. So you might be paying your Unisearch fees a little bit out of, you may not need to.
Fair enough. So now we're on to 910. And this is termination of your foreign registration. So A, Secretary of State may terminate the registration of a registered foreign LLC in the manner provided in subsections B and C if the company does not, subsection 1, pay not later than 60 days after the due date any fee, tax, interest, or penalty required to be paid to the Secretary of State under this act or law other than this act. And the parallel in the ORSs is 63.737. And this is, they're sort of out of order. This is sub 2. And under current Oregon law, it's just you didn't pay it on time. ROLCA gives you this 60-day grace period, which we struck in the domestic entity dissolution section. So I think we would strike the 60-day clause here. Sub 2 under 910A, if your company does not deliver to the Secretary of State for filing not later than 60 days after the due date, the annual report required under 212. This is parallel to 1 under 737. And again, the 60-day timeline would come out. Sub 3 in ROLCA, have a registered agent as required by section 115. The parallel is 737 sub 4, again, going out of order. Foreign LLC has failed to appoint or maintain a registered agent or registered office. ROLCA sub 4, deliver to the Secretary of State for filing a statement of change under section 116, not later than 30 days after a change has occurred in the name or address of your registered agent. The parallel is sub 5 in 737, not informing the Secretary of State that your registered agent or office has changed. I guess here we do have a 30-day window in ROLCA, and I don't know that there is, at least there's not in 737 sub 5, a specific window of time. So those are the 4 grounds in ROLCA. We have additional grounds in current ORS. Sub 3 of 737 is a failure to comply with an order from the Secretary of State. And this is, what was that, House Bill 2191, where the Secretary of State has authority to investigate shells. So I think 3, clearly we need to import. Similarly, sub 6 of 737, if you've signed a document knowing that it was false, same reason, we should import that. And then sub 7, my favorite wonky clause, rears its head again. A foreign LLC no longer satisfies the requirements of 714 sub 3. Just keeps giving. Or 8, if the Secretary of State receives this one was kind of interesting to me. If the Secretary of State receives a duly authenticated certificate from the official having custody of the LLC records in the state or country under whose law it was organized, stating that it has been dissolved or ceased to exist as a result of a merger or other reorganization transaction. I was just envisioning somebody could proactively send something in about an entity that they don't represent or have any connection with, and this seems to say that the Secretary of State, if they learn that you've been dissolved, they will terminate you. I don't object to that. Seems like the right end result in any event. And then 9, if your period of duration as a foreign LLC expires, then you would also lose your authority. So to the extent we're retaining that, that makes sense to continue here as well.
So what I'm hearing you say, James, is that we pull in all of these items that are in 63.737 into ROLCA. That would be your recommendation.
Other than the wonky one, which I don't want at all, but yes,
Okay, other than 7.
that's right.
Okay.
I agree, although I think we should not import 9, the duration one. In section 708, we had the same discussion and decided not to incorporate the equivalent. So I just think for consistency, we should.
Well, for a domestic entity, isn't that because we got rid of duration as part of the articles? So I think here, if you had a Idaho entity that did have duration,
Oh, okay.
Secretary of State does in fact track that currently.
So maybe we add that same sort of throat clearing language like we talked about with the registration statement in the first place.
Yeah, agreed. Okay, so now we know why you get revoked. So let's talk about the process. B in ROLCA, Secretary of State may terminate the registration of a registered foreign LLC by 1, filing a notice of termination or noting the termination in the records of the Secretary of State. And the parallel here is 63-741 sub 1. And it says that the Secretary of State shall give notice, written notice of the determination. Going back to ROLCA, it says that the Secretary of State will deliver a copy of the notice or the information in the notation to the company's registered agent, or if the company does not have a registered agent, to the company's principal office. And I assume that's exactly what happens today. Jamie, is that right? That there's some notification goes out to the registered agent?
Yes, we do have a notification that goes out if we're going to be dissolving them or withdrawing them.
Okay, so no change there. C specifies what that notice has to say. It must state, or the information in the notation must include, the effective date of the termination, which must be at least 60 days after the date the Secretary of State delivers a copy, and 2, the grounds for the termination. Current Oregon law is in 741 sub 2. Substantively the same, other than 60 days is 45 under current Oregon law. So I think we would change that to 45.
Mm-hmm.
And then D, the result, the authority of a registered foreign LLC to do business in this state ceases on the effective date of the notice of termination or notation under B, unless before that date, the company cures each ground for termination stated in the notice or notation. If the company cures each ground, the Secretary of State shall file a record so stating. In 741 sub 3, we've got the authority ceasing as of the date of revocation. So I think that is effectively the same. And then we've got sub 4 and sub 5 in 741 talking about service of process again. So we would need to import these concepts that once you've been revoked by the Secretary of State, you have appointed the Secretary of State as your registered agent.
Say that again?
So we would want to import the concepts from 4 and 5 about service of process to make sure that we've still protected the concept of the Secretary of State being deemed your agent for that purpose.
Yeah, part of me was wondering, because we have all these provisions in Article 9 about withdrawal, transfer, conversion, all these different things, and we're wanting to say for all of those different instances that that the Secretary of State is still going to be your agent for purposes of service, and none of these things end that. And I was wondering, rather than add language to each of these parts of Article 9 or add comments to each of these parts, maybe in section 119, where we talk about how the Secretary of State is your agent for service, we just add a sentence there that says withdrawal, termination, etc., transfer doesn't affect the appointment of the Secretary of State as your agent afterward. And that might be cleaner, I thought.
Yeah, I think we in part are letting legislative.
Sorry.
Yeah, I think we're in part deferring to legislative counsel on how it gets done, but I agree with you. I think that's a better way of framing it and simpler.
Thanks. Can I ask a question? I noticed, when we were talking about how there's under 63,737, there's more grounds for revocation than there are for domestic LLCs. And I'm just curious what the policy rationale is for being able to revoke a foreign LLC if they're submitting false documents, but not being able to do that with a domestic LLC. Or why is there a distinction there? And likewise, I know we just got rid of the 63,737(7), which talks about the foreign limited liability company is doing things in Oregon that are illegal here. But I guess I'm just kind of curious if a company is, the Secretary of State knows a company is doing illegal activities here, why wouldn't we want them to be able to terminate or revoke, whether it's domestic or foreign?
So when I said there were more grounds in 737, I was comparing that to ROLCA.
Right. But when we did, because we went over, did we in 708, did we, I guess, modify 708 of ROLCA, the domestic one, to encompass this sort of fraud on the office of the Secretary of State or engaging in illegal conduct?
I do have notes about incorporating a few sections of existing Oregon law, specifically 647, 3 through 5. Yeah, which is the state order, registered agent, changes to your registered agent. So yeah, I think we did broaden the ROLCA dissolution process to incorporate the grounds in current Oregon law that weren't present in ROLCA.
Yeah.
I didn't say that very eloquently. Did I answer your question?
Cody, the reference goes from 647 to 63032, which is the violations provisions.
Yes, and I know we're still having the 032 reference
Right.
for foreign LLCs, but I don't think, like, just under current Oregon law, tell me if I'm wrong, but I'm not seeing where in 647, the domestic LLC one, where's the analog to 737, 6, 7, or 8, which talk about how you can revoke the foreign LLC's authority if they're giving you false documents, if they're engaging in illegal conduct, I guess 8 makes sense if they've been dissolved foreign, like you don't have a local version of that. But what about 6 and 7? Why don't we have an equivalent for domestic LLCs?
Well, we do, as part of that. You go from 647 sub 3, right, which tells you to, they can dissolve a domestic LLC, and we are specifically incorporating that into this. And that takes you to 63032, which is the provision that talks about an investigation by Secretary of State or a request from law enforcement. And if they don't comply with that, then Secretary of State does have the authority to dissolve them.
What are the grounds under 032? Like, what is the bad conduct that 032 gets you in trouble for?
An alleged or potential violation of this chapter, and in the course of an investigation or in the response to a request from law enforcement, may order a limited liability company to do stuff.
Well, if we think 032 covers conduct that is otherwise described in 737(6), we need to get a reference to that as well then.
Sorry, somebody's got their lawnmower going in the background. I'm sorry, what was that, Cody?
So 737(6) says you can revoke a foreign LLC if they sign a document knowing it was false so that it would be submitted to the Secretary of State.
Right.
If that kind of bad conduct is covered by 032, then I think it's redundant to have it be here, incorporating that into ROLCA now, which is what I think we had just talked about doing. If that's not covered by 032, then I think we want to have that same ground for revocation/dissolution applied to domestic LLCs as well as foreign.
I wonder if this is a question for legislative council though, because you know they can look at how they reconcile these provisions within, you know, I think if we tell them that our intent is to have foreign and domestic entities, you know, other than the foreign documents issue, but be generally the same, which makes sense to me, right? You have bad acts on either side, foreign or, you know, domestic, you'd want to be able to dissolve them. You know, if Sean might be able to suggest some workaround there.
Okay.
But your point is well taken. And I'm going to add a note both to my 708 and then here.
So I think this is the logical place to mention a couple of sections in Oregon law, current Oregon law, that are not present in ROLCA. So 63.744 has a process to appeal from a revocation. And I think we preserved that when we talked about domestic entities. So I think we would probably preserve this as well. Similarly, 63.747 has the concept that within 5 years, if you need to reinstate because you forgot what you were doing, you didn't file, you can get reinstated and it's retroactive. You just pay your back fees. I would imagine we probably want to do the same thing there.
Mm-hmm.
You know why ROLCA didn't include similar provisions?
There was somewhere in the commentary, there's a reference to minimizing the inconvenience with registering, and that there was a concept about not requiring the payment of a bunch of back fees as a potential impediment to people registering. The idea being, let's, you know, people have good faith disagreements about when to register. Let's not provide a disincentive. Let's just make it really easy to register. That's the only thing I could find on concept, on sort of related. I think it's pretty straightforward that if you get denied, there's really not much harm to reapplying once you've fixed whatever it is. And do you really need a court process? Are you really going to hire a litigator to file a lawsuit? That seems incredibly expensive compared to redoing a one-page form once you've fixed whatever was wrong. And it may well be implied, frankly, that you have an Administrative Procedures Act claim anyway, if the Secretary of State is actually getting it wrong. That's the best I've got.
Does 63.747 deal with administrative dissolutions and reinstatements? Does that also apply to it? Because that's been useful for me on many occasions to reinstate something that was administratively dissolved.
And there is
Yeah,
section
there's
709 on
reinstatement. So there is a separate section, Jeff, for reinstating a domestic entity. This is just the one for the foreign registration.
But it was the same question. If they don't file the annual report and get administratively the foreign registration dissolved, would this section apply to reinstating it if it's just a situation where you didn't file the annual report and pay the fee?
Yes, this would allow you to reinstate going back retroactively 5 years.
I like having that. I'm not sure why ROLCA excludes that for that reason. I mean, we probably all have run into administrative dissolutions where we like to reinstate, because I've also had situations you go beyond the 5 years and then you've got to actually essentially file for a new entity or start all over. But the 5 years is a good mark, and it saves a lot of problems. And I believe it relates back as well once you do the reinstatement.
It does. I'm recommending that we import 747 into ROLCA.
And I'm agreeing with you.
And James, just so I'm clear, what's the difference between that and 709?
You're not actually administratively dissolved by the Secretary of State as a foreign entity. All they can do is cancel your ability to do business in the state. So your foreign registration is canceled. You're not dissolved under Delaware law, for example.
Got it. So, I mean, to that point, can we just do for reinstatement, say nullifying cancellation or something to that effect in 709 and simplify it?
I'm indifferent to the drafting.
I kind of like having it in the foreign entity place because I think that's where people will be looking for it.
And in Article 9 is all about foreign limited liability
Yeah.
companies. That's what the article is about. So I think it's logical to leave it in there.
Yeah, I mean, I approve of the goal of simplicity, but I think from a logical perspective, I'd like to keep it in 9. Okay. So James,
right.
recommending adopt incorporation of 744 and 747?
Yes.
Okay.
Based on the prior changes we did in ROLCA Article 7.
Okay.
Okay, so we're up to 911. Withdrawal. A registered foreign LLC may withdraw its registration by delivering a statement of withdrawal to the Secretary of State for filing. The statement must state the name of the company and its jurisdiction of formation, that the company is not doing business in this state, and that it withdraws its registration to do business in this state, that the company revokes the authority of its registered agent to accept service on its behalf, and an address to which service of process may be made under subsection B. In current Oregon law, we are in 63.734. Foreign LLC authorized to transact business in the state may withdraw by filing an application for withdrawal. Application will set forth. Really the only substantive difference, I mean, A matches 1, B matches 2, C is similar to 3, and 4 is the same as D. In C, you've got language about appointing the Secretary of State again. So we're going to want to preserve that concept, and we can flag that for Legislative Council. A little bit different in current Oregon law, we have subsection E, which says that part of your statement includes a commitment to notify the Secretary of State for a period of 5 years from the date of withdrawal of any change in your mailing address. Which frankly, I've never read those words until preparing for this. I was surprised by that. And I found it kind of interesting when looking at ROLCA sub A4, it talks about providing an address to which service of process may be made under B. And then in B, it says after the withdrawal, service of process from your time in the state may be had pursuant to 119. What's interesting though is the comment, which says the statement of withdrawal must set forth an address where service of process may be made. There's no limit on how long the withdrawn company must keep that address up to date. I don't see that in the text of ROLCA. It's talking about a filing and what needs to be included in that filing. I don't see the obligation to update the filing if your mailing address changes. But in any event, Oregon law currently says you need to do that for 5 years. So my own view is we should be express about whatever the requirement is, whether it's into perpetuity or for 5 years. I think we should say so.
Wouldn't a statute of limitations on most claims kind of play into a 5-year limitation?
No.
5 seems pretty logical to me. Yeah.
Cody says no.
Well, I mean, the statute of ultimate repose is 10 years, and that's for negligence claims, for intentional torts. Essentially, the statute of limitations is forever. It's like 2 years after discovery. So, I mean, I think if the question is just, if it's not a policy question, it's just one of what rules should we have, 5 years or some other number of years or infinite? I think if the answer is infinite, then ROLCA says that sufficiently. If we want to discuss, we should have as a policy matter, a different time period. We can do that. But I guess what's the question? Is the question, what should the substantive policy be? Or is it just how do we say that, whatever the policy is?
Well, the current is
Well,
5
first-
years, right, James, in Oregon?
Current Oregon law is 5 years.
And I think it's reasonable that we not make a policy decision that that's an incorrect thing.
And the Corporate Act has a similar provision.
Yeah. So, I mean, I think language tying this to the, is it 63,734? Let me pull that up. Probably makes sense.
Well, and one thing that they don't have in ROLCA that we do have is service through the Secretary of State, at least as we have modified ROLCA. We will be having that now. And so, as I understand ROLCA, they don't have that backstop of service through the Secretary of State. And so you would want them to have this perpetual duty to give you the address that they can be served at. Of course, the problem is they don't. And then what do you do?
Right.
And that's why it's important to have the Secretary of State as the backstop. So since we're still going to have the backstop of the Secretary of State, even if they don't update their mailing address after 5 years, I think it's fine to limit their requirement to update their mailing address to just the 5 years.
Yeah. So incorporate current 63,734 1E.
Yeah.
Makes sense to me.
Yeah. All right, 912 is really controversial. That's tongue in cheek. The Attorney General may maintain an action to enjoin a foreign LLC from doing business in this state in violation of this article. I think we all hope and expect that the Secretary of State has that authority. I think it's good to make it
Comment's
express.
pretty good. I like the comment on this one.
Yeah, I agree. A couple other concepts I wanted to mention in existing Oregon law. We have currently in Oregon law two sets of parallel provisions, or two parallel provisions for registered agents. We have a section governing registered agents for domestic entities, and then other sections for foreign entities. The foreign ones are in 63,721 and 724, 727, and 731. Sorry, 731 is about service, which we've already supplanted with 119. But anyway, appointment of a registered agent, changing your registered agent resignation. We've already talked about all these in the domestic entity context, and I'm comfortable consolidating those. Just thought I would mention it. The only other thing, Valerie, that I had, this is more of a conceptual question. When I was looking at Article 9, I pulled the RCWs to see what Washington did, just for my own benefit as I was working through these issues. And I stumbled on how they dealt with the hub and the spokes, which I hadn't really dialed in on yet. So it's really kind of unusual in my mind. If you go to the foreign LLC section where you would expect to learn, for example, the internal affairs doctrine, the law of your jurisdiction controls your internal affairs. When you go to that section in the RCWs, it says, the law of the state of your jurisdiction governs your organization as provided in. And then it points you to this other grouping of statutes that is the hub.
Right.
So it's sort of this second set of parallel provisions cross-referencing you to the hub. And I'm just flagging it as, I don't know how we're dealing with the hub. And I assume at some point, somebody's going to give that a bunch of thought.
Yeah, and I think it's probably not. I think it's probably not until we start thinking about the Corporate Act that we would probably want to, streamline things that way. Because then we'll be because there's so much to interplay. But I appreciate your
totally agree. Are you thinking then that potentially when the Corporation Act gets done, we're also revising ROLCA again to basically import the hub to ROLCA?
Yeah, I mean, I think that's going to be a drafting decision for that group, right? Because, we've tried to be consistent. Michael's been really good about flagging areas where, the Corporate Act says this, so let's not mess with that until we, are actually talking about the Corporate Act. And so, there may be efficiencies to be gained by creating, you know, the hub concept. You know, the way that they've built Rulka is that it can stand alone. But, you know, as we've been talking about throughout, and when we started talking about this whole project, it was with the understanding that, you know, the idea is that there's commonalities between these entities that and things that we want to keep consistent just because of what people's expectations are. So that's what I'm thinking anyhow. I mean, does anybody have different thoughts on how to approach that? No.
I think that makes sense.
Okay. Well, that was a huge amount of work, James. Thank you so much for doing that.
Thanks, James.
Yeah.
Of course, happy to.
I have one question on 63.731. Talks about how you can do service through the Secretary of State on a foreign limited liability company that is never registered. And that's referencing both 63.731 to C and E, talks about unregistered LLCs. And 119 talks about the Secretary of State being the backstop when you are registered,
right,
domestic or foreign. And so I think we should add some provision to 119 that talks about if you're foreign and you're doing business in Oregon, the Secretary of State is still the backdrop. And there's reference in 731.3 it talks about when the foreign LLC is not authorized to transact business and was not at the time of the transaction, you know, then you can do that by the Secretary of State. So I think we should add something to that effect.
I think that's a very good suggestion. I'm just finding my 119 so I can make a note. Okay.
I definitely agree with that.
Does that make sense though? I mean, so to be clear, we're talking about a foreign LLC that does business in the state of Oregon. It doesn't register to do business in the state of Oregon. It does something wrong in the state of Oregon and somebody wants to quit. And sorry about that. Therefore they can serve the Oregon Secretary of State because they never qualified to do business in the state and don't have a registered agent in the state. That's the fact pattern, right? So is that, I'm just asking, I don't know. And I'm just asking, is that due process? I mean, the idea of service is to make sure somebody's aware that they're being sued. Is that legitimate due process? The only connection is they did business in the state. They're not registered to do business in the state, and we're serving our Secretary of State. What's our Secretary of State going to do with it? I mean, how do they get notice of the lawsuit?
I suspect Teresa wants to say something about this.
Yeah, I mean, this goes back to the waterfall provision that you have for service of process, which is that you're supposed to try and do real service first. And where this is going to come up are in things like foreclosures, where that LLC doesn't really exist anymore, but you still have to give them a notice in order to be able to have an effective proceeding go on. And if they're a foreign LLC and they've done business here, and you serve them through the Secretary of State and they don't get notice, then, and you're actually ever able to find them somewhere else, what you're just buying yourself is a fight that they're going to say, we weren't really doing business in Oregon, and therefore you didn't have jurisdiction over us through that service with the Oregon Secretary of State. So if you get to the point where you're going to be able to serve them, you're going to end up having that fight anyway. This is kind of the service of last resort. If they're not registered here and they're doing business here and you have to be able to serve them and there's no other way to do it, sending it to the Secretary of State is better than nothing. Because it's going to stop you from not being able to go through with remedies that you need to be able to go through.
Does the Secretary of State have any obligation if they're the service of last resort and they receive service?
Nope, they don't do anything with it.
They're supposed to mail it, aren't they, to the last known address?
No, it's up to the person who is sending the documents or serving, to mail it to the last known address. The Secretary of State, basically, we receive $20. We file it into a database. About 60 days later, we put it in a big barrel to be recycled. So we don't ever do anything more than that. We don't try to search for anyone or
Literally
send them any
around-
documents.
Is that yeah, I love the barrel
That's
part.
amazing.
Database accessible to the public.
Jeff, you're cutting out quite a bit.
Is that database accessible to the public? So, you know, there's at least a way to access it.
If somebody wanted to see if something was served, then we do have that and we keep a record. And we also send an acknowledgement to whoever served us so that they know that that we received it. But other than that, as far as the actual documents, those we do not keep very long, and we don't have.
Yeah, so if you were a foreign LLC that wasn't registered to do business in Oregon and you were worried about someone suing you in Oregon State Court and serving it on the Secretary of State, you can always contact the Secretary of State's office and say, hey, have you received any service of process for me?
Mm-hmm.
In which case you would find out about it and be able to do anything about it. But I think short of someone being that proactive, they probably don't find out about it at all.
And as the plaintiff in such a suit, your goal is to try to get this judgment that's enforceable. And it's not going to be enforceable if there was no good service. And so you're gonna, as a practical matter, do what you can to actually find, you know, the person who's behind this LLC and get somebody served. The manager from Nevada or the owner or what have you. You're going to try to do that because you want to make sure you don't want to have a fight over sufficiency of service and all of that kind of stuff. But if you can't do any of that, then you're going to do the Secretary of State, or at minimum, you're going to do the Secretary of State as a belt and suspenders approach, in addition to whether you may do publication as well as Secretary of State or something like that. We all know how real, you know, notice through publication is, but you know, it's all ripe for constitutional challenge, I'm sure. But what else can you do if they're in here fly by night doing business? You got to have some kind of statutory backstop, I think.
Makes sense.
Okay, yeah, I do in the due process, and I feel like others are as well. But I agree, it should be there as a last resort.
Okay, a little bit of housekeeping. First, I'd like people to volunteer, please, for the provisions in, because Article 10, which will start next time, is broken up into 5 different sections, and then we have Article 11. So I'd like to get those signed this time, and I'd like to set our May meeting, because we already have April.
We do. April 9th is when we're set, and
Yeah.
that's a Friday.
That's a Friday.
So if just going off availability for folks, we did the Tuesday this time to make sure Mosin. So yeah, we did a Friday, so we're kind of open for May, just trying to keep it available.
Right. So what are people that week of May 3rd? What does that look like for folks? I mean, my life is horrifically boring right now, so I'll be here.
How about this? What is the day what day of the week we want to do? Is it a different day than Tuesday then? Like we're looking for like a Wednesday?
The academic semester will be over by then, so that wouldn't be a conflict for Roberta or myself.
That's true. I'll probably have to track finals, but it's one of those things, if I need to leave the call for a second, I will. But we can do a meeting that week.
Would Wednesday or Thursday work? Those are better for me than Tuesdays.
Both work for me. Does anybody have a preference as between Wednesday and Thursday? Why don't we pick the Wednesday then? Cinco de Mayo. Make it easy to remember.
Okay.
Okay. So Wednesday, May 5th. And then Sandy will send out the calendar thing as well.
Yeah, April 9th and May 5th. I'll get those out.
Yeah. Okay. And so Article 10 deals with mergers, interest exchange, conversion, and domestication. And it's kind of an interesting section, actually. I was skimming it. So I'm looking forward to our discussion on this. Now, the first section is the general provisions, and the second section is merger, and then interest exchange, and then conversion, and then domestication. Does anybody right off the bat want to volunteer for one or more sections? They just start randomly calling names as we go across the list.
I'll just throw out that I don't know anything about any of this stuff, and I assume there's not to volunteer the transactional attorneys, but to volunteer the transactional attorneys. I wonder maybe it's best that the leader be somebody who does mergers and acquisitions and things.
I can do part 2 mergers. I just don't want to sign up for next time around because it's going to be busy before next time around for me.
Sure.
So I hesitate to sign up for part 1.
Sure, and we could pair. I mean, people could pair up with someone. That worked well. David, would you like to do a section?
Of course not. No, I'd be happy to do something.
Do you want to do part 1 with me, and that way we can work together on it?
Sure, that'd be great. Okay. It'll be a challenge, though. Not to work with you, but the section will be a challenge.
Well, between part 1 and part 2, it's going to be at least 2 or 3 meetings worth of material.
Yeah,
so
I think
we're good for a while.
These are dense sections.
They're dense, yeah. And some of them may be so intersectional referential that we may do like we did with Article 1 and keep coming back to it. So who nominally would like to take interest exchange?
Do we have an interest exchange concept under existing Oregon LLC law?
No,
No.
I don't think so.
I mean, so that I think that opens up a question of whether we want to incorporate one because it doesn't get used in practice as far as I'm aware.
Well, I think we should at least talk about it.
Fair enough. How about I'll be willing to talk about it if the talk can be whether we should even have it or not before we get into the details of it, because the transactional lawyers will tell you it doesn't get used.
Okay, I'm gonna ask Cliff, would you mind working with Mohsen on this section? I want someone who might be tempering influence on his hatred of this section.
Well, I mean, there is that threshold question he poses.
I think that's fine. I just think we can't just decide to skip it without looking at it.
No. I didn't mean to suggest that. All I mean to suggest is I think before looking into the details of these sections, which could take up one or more committee meeting,
yeah.
we should ask the threshold question of what is an interest exchange and why would we want to incorporate it into our law?
I think that is absolutely a reasonable question to ask.
Okay.
And if you could explain it at like a 30,000 foot level, saying here's what this says, here's why it's garbage, and we're not going to do it, then I think that's fine too.
Okay.
Jeff, what section would you like to do?
I was just going to offer myself up. How about I take part 4, conversion? I'm pushing off because I've got a really heavy couple of weeks in front of me.
That's fine. That's fine.
This will give me a month or 2. I'll take conversion.
Okay.
You'll have
Jeff,
months.
if you want a partner there, I would be your partner in crime again. If we want to pair part 4.
Absolutely, Michael. It'll be our second time to the rodeo together. Good.
Look forward to it.
Domestication. Who would like to talk about domestication? James, would you
Isn't
like
that kind of the same thing as conversion?
Well, I think the person who takes 5 probably should make a decision about that. It's the same thing.
I'm happy to take another part. Yeah, I'm happy to take another part. Happy's probably the wrong word, but I'm just wondering whether part 4 and part 5 are, I think there's some overlap.
And do you want to coordinate with Jeff and Michael on that? Because if it makes sense to consider them as a unit, then I think that makes sense as well.
I mean, I think it is, just domestication is a different concept. I think it there's some parallels, I think, to the foreign entity sections. when you think about what it does.
Okay.
Valerie, do we actually, like with the interest exchange, do we want to have maybe a discussion at the next meeting, just saying, do we need to look at the domestication part 5?
Well, I mean, I think that, well, first of all, well, I think it's reasonable, maybe not at the next meeting, but as we're approaching domestication, to have a discussion. And I think a lot of this stuff, it would be helpful for particularly the non-transactional lawyers in the room, if whoever is leading the discussion can give an overview of what does this section say? What is it trying to accomplish? You know, do other states have it? Is it something that we use?
But yeah, to that point, like
Yeah.
domestication, as far as I think about it, is literally the same as conversion. So I'm curious how.
Yes, I don't think we have to have it.
I thought, yeah, we can talk about it later, but I thought they were completely different things. But
There's an overlap. I think they're different, but there's an overlap.
I just try to get these sections assigned, people. If we don't end up talking about them, I'm cool with that too, and in great detail. Okay, and then we would wrap up with miscellaneous provisions, which doesn't look like it's terribly long, but we do want to appoint someone to talk about that. Who would like to talk about that?
Article 11.
Yes, Article 11. Teresa, would you like to talk about that?
I will take on Article 11 because I'm sure that I don't understand most of Article 10, but I think I can probably get my brain around Article 11.
Okay, great.
2 pages, you'll love it.
It looks short and like I can probably manage it.
It does look short. I think a lot of these sections aren't really super long, but like we're saying, I think they're pretty. Some of them are pretty dense. So, okay. Thank you all again. I really appreciate you. I am so happy that we're as far as we are in this process, and that we've been able to make such good progress. So look for an email from us. Sandy, most likely, given the public records requirements of this committee, basically transmitting the draft or the Word document of what we've been working on, and then to the extent you have sections, and I'll include a list of who did what section, but of course you should remember. And then if you could focus on that particularly, and then we can have a central place where we can keep comments. My request would be that you just do your markup, and then we can run a red line so that we can see how stuff is evolving.
What I think, what I can do is I'll just send back your section with your notes, and then I'll add those to one singular document that can be shared on a cloud that we can all do comments on. So does that make sense?
I think that makes sense.
Yeah.
So people just focus at least initially on their own section, and then we'll have a cloud document like a Google Doc or something that people can go in and say, okay, here's the changes that I think we made that aren't reflected.
Okay, so we're going to get something from Sandy that says, here's the clean version. Exactly. We're going to look at our section and add the changes that we think are what we did to our section, and we're going to send it back to Sandy. And Sandy's going to collate all of that and make it look pretty. And put it in some place where everybody can see it.
Yeah, and then we can all go in like a Google Doc, because the Google Docs are nice because they show who made edits to the existing document, and to the extent that there are things that maybe I wasn't taking great notes when I was doing my section, and you remember something differently, or there's an additional piece of information, then you can add that into that second round.
Okay,
I think that'll be the most efficient way to do this. Certainly more efficient than me trying to incorporate everything.
I agree, yeah.
All right. Thank you again. I really